Good morning. I'm Susan Watson, and this is the Student Conduct Title IX and ADA presentation. Kathy Camp will be presenting directly after me, and welcome. Thank you for joining us this morning. So I'm going to start right in with the ADA. It is technically the Americans with Disabilities Act Amendments Act of 2008. Americans with Disabilities Act Amendments Act of 2008, and it became effective in 2009. Civil rights law, and it protects individuals with disabilities from discrimination in the workplace, at school, and in other settings. At Prince George's Community College, student disability matters are handled by Disability Support Services. Thomas Mays is the program director, and as you hopefully know, they are in Lanham Hall. Employee disability matters are handled by Sabrina Thomas in HROD, and I am the ADA coordinator. I'm consulted as needed, but usually I am dealing with matters that are escalated to the president of the college, and that would include complaints from the Office of Civil Rights, usually. Sometimes I'm also brought in just to consult with Sabrina or Thomas on an issue or two that comes up with faculty or with students. This presentation focuses on accommodation of students with disabilities. We can go into more depth regarding employee disability matters at another time in Faculty Senate, in a different setting, if that is desired, if people want to talk about the employee side of disability. But most of what we're talking about here is going to be focused on students with disabilities. The ADA regulations define a disability as a physical or mental impairment that substantially limits one or more major life activities, and this is sometimes referred to as an actual disability. It also defines it as a record of a physical or mental impairment that substantially limits a major life activity. So this is having a record of a disability. And then there's something called regarded as, which is when an employer, or in this case, faculty, takes an action prohibited by the ABA because the actual or perceived impairment is not both transitory and minor, but they regard the person as having a disability. So in this instance, it would be if a student said something about that they would rather sit in a certain location, or that they need a certain sort of accommodation, and the faculty does that without a form, then you're regarding them as potentially having that disability. And in the workplace, certainly that would happen as well, where supervisors allow for an alleged disability that an employee says he or she has. Then that's something that can create a situation where the college is going to have to continue to accommodate that individual. So that is why this slide says, do not offer accommodations on your own. Utilize Disability Support Services or HROD as appropriate. So again, this is Disability Support Services. Thomas Mays is the program director. Adrian Moore is a rehabilitation counselor, and Leslie Jones is the administrative associate. So in terms of ADA for students, transitioning to college can be an easy decision, but graduating may be a long-term goal, because the disabilities can impact the student's ability to matriculate in a timely fashion. Becoming a student of the college is basically applying, taking the placement test, and then the person can become a student, because we are in the open admission. But after 3 years of enrollment, only a small percentage of our students achieve successful outcomes. So this is why it can become a longer term goal than the student initially anticipates. Recent data indicates that 60% of Prince George's Community College's first-time credit students enroll in a developmental course. And this may or may not be students with a disability, but 70.2% of all credit students also enroll part-time. And sometimes students just do not realize that the idea of getting their degree or getting their certification in 2 years is really impacted by all of these factors. So sometimes students may enroll thinking they're going to graduate quickly, but that's not often the case, and it can be something that becomes an issue for a student with a disability. DSS counsels students that college is different from high school. So Thomas is doing a session with the students in convocation and addresses the students this time, and we'll be doing it during this August, but also new students in January. And he emphasizes that students need to engage the instructors, understand the syllabus, self-advocate, become directed learners, expect remote and online work, ask questions, and understand their own disability. He also emphasizes that the college requires time management, adjustment to the pace of classes, understanding college policies and procedures, abiding by the code of conduct, developing and applying study skills, and monitoring one's own progress. So this is where students who may be used to an IEP, used to their teachers in high school giving a little more attention and helping to guide them, as well as their parents helping to guide them in their educational setting. College requires more of them, and so this is the expectation that DSS tries to set with the students. What we'll talk about for a little bit is the accommodations. And so I wanted to kind of go back and look at what accommodations mean. And accommodations is when we provide what is needed or desired for convenience. It's all about making room. This was a definition I liked from vocabulary.com, that accommodation is about making room. And I was thinking about accommodating guests in my home, and it can be making room or a place where someone will stay, or accommodating someone by making room for their special circumstances. But basically it's meeting a need and making something suitable, and at times adjusting to the circumstances in order to do that. So we're talking here about accommodations, not modifications. And that's really an important point, because I think that where students are asking for or looking for modifications, that should not be granted, and it should not impact the US faculty and your educational experience in your instruction in a way that significantly impacts how you are handling your class. The goal is to have it accommodate and not be a modification, not be a grand burden on the college, on you as faculty, but also to assist the student. So an accommodation allows a student to complete the same assignment or test as other students, but with a change in timing, format, setting, scheduling, some change that does not alter in a significant way what the test or assignment measures. A modification would be an adjustment that changes the standard or what the test or assignment is supposed to measure. That is not what we're talking about. So modifications might lower the curriculum, simplify the materials, change the way the grading occurs, lower expectations. But an accommodation is environmental. It's where a student sits. It's airflow. It's the presentation of the class in the way that it's presented, possibly needing a sign language interpreter, assistive technology, assignments, the way that assignments may be given. And this may in particular apply to pregnant and parenting students. But there's certain things that we would consider accommodations, and we're not talking modifications. We are talking about accommodations and what we need to do to help our students continue to matriculate when they have a disability. So possible accommodations based on documented disabilities may be extended time on tests, note-taking services, which are limited. There are not a lot of ability for note-taking services. We are one of very few colleges or community colleges in Maryland that give note-taking services. Potentially an alternate testing site or location. This, of course, has changed during this online era. Permission to take record lectures. Again, all most lectures, from what I understand, are being recorded for students. So these sorts of things are what happens. And the process is that the student has to document their disability and register into the college, and then DSS will do an intake and give them accommodations. So the accommodations process does not start in earnest until after a student registers. This is what the accommodation form looks like. I know it's kind of shrunken down, but you should be receiving this from a student when there's a particular accommodation that the student's entitled to. So I'm going to look at a couple of questions here. One says, for those who had a 504 plan, not an IEP, they cannot get services through DSS, correct? Students do not have to have had any sort of accommodation in high school to get services through DSS. A student who can document a disability coming into the college would be able to apply for services through DSS. There's no requirement that links this to the K-12 setting at all. So I'm hoping that answers your question. Another says, how do these accommodations apply these days in remote synchronous and online asynchronous classes? What types of accommodations beyond recording lectures? My understanding would be that in general, students would still be able to get, for example, sign language. I know that that can be difficult in the remote classes. I was just emailing with Thomas about that yesterday. That's something that can be a challenge, but they can still get that. They can still have the interpreters. I would think that they should still be given extended time on testing. However, that is done through the online platform, and however that their testing time is extended, I do believe that that is something that that they should still be given. So things like that, I think, are a couple of things I would list, and certainly I can see if I can talk with Thomas, and if you have more of a question, we can deal with that. And then it's asked, how come the faculty does not have to sign the form also? I've had students complain they were not helped, but then my faculty said they never saw the form. If the faculty had to sign the form, there would be no question. You know, I can ask Thomas about that. To some degree, it sounds very high schoolish to me to have faculty have to sign it. I think that there needs to be some understanding of whether the student actually requested it. So that is something that I will talk to Thomas about and see whether that makes sense to do. And in fact, whether we're able to do that. I don't see why we wouldn't be from my recollection of the law, but I'll check into that with Thomas. Let me make a note and see how what that answer might go forward being. So I'll check on that. And I will address pregnant and parenting students shortly. So I'll move on a little bit here. So accommodations are not provided if the accommodation would fundamentally alter the nature in which the course is given, if the institution is being asked to address a personal need, and if the accommodation would impose an undue financial or administrative burden. So this is when the accommodation, even though it may be a valid need from the student, would not be something that the college would do. For instance, The college does not provide individuals to push someone's wheelchair from class to class. That would be a personal need. A personal assistant would need to be engaged. But if someone had an automatic wheelchair, an electronic wheelchair, but couldn't get through a door, that is something the college needs to be able to give as a physical accommodation. But at times students are needing more assistance and personal assistance in a way that does not provide, that the college cannot do, and is a burden on the college. It's undue financial burden or an administrative burden, or in the classroom would alter the nature in which the course is given. So I'm seeing a lot of questions and a lot of hands, but I do have a lot of material to cover. So I'm going to hopefully come back to some of these as we move forward. I do see one saying, if the student needs a desk for a wheelchair, who requests the desk to be put in the classroom? The student should ask for the desk through Disability Support Services, and they would then move forward with accommodating the student in the right classroom with the right sort of desk. So that's something that would be done by Disability Support Services if the student requested that. How will we be notified for remote classes if a student needs accommodations online? And these questions of how the notification is going to happen, my guess would be that it's going to be by the student through email. I will check with Thomas to make sure of that, because I do believe the student is supposed to approach the instructor, not DSS. So the student should be emailing with instructors, and I had spoken with Clay about some of the concerns where students said professors are not responding to email. And I think that many and most of you probably are, but it is imperative that you check your college email and respond to students. And then what other than extra time? Like I said, there are many other accommodations that happen. I think a lot of them are happening regularly with the recording of the classes and things of that nature. But it is something where extra time is one of the main things that's requested. And I think that giving materials that are being used online is another thing that may be happening that potentially wasn't already scheduled to happen, that whatever it is that you're using that you may put up in class, that it all has to be posted. I don't know if that's always been, but I can send you a more extensive list of the types of things that are accommodations. And I'm going to make a note of that now. Now I see a few hands raised, including Clay's. So I'm going to see if I can figure out how to give him, Joseph, the floor. I don't know if he just unmutes. And if that's the case, then we will hear from Clay. Joseph, if there's something I need to do, please let me know.
Talking about the issue with students getting responses from their instructors. I was talking with the chairs and the deans the other day, and I think our understanding is that 24 hours is generally expected reply time, except weekends. But if one of the deans or the chairs remembers it differently than me, 24 to 48 hours, 48 at the outside, but that would accommodate weekends, but ordinarily around 24 hours would be the expected reply time or response time. Thanks.
Great, thank you, Clay. And now we're in Title IX. So Title IX of the Education Amendments of 1972. The key phrase, no person in the United States shall, on the basis of sex, be excluded from participation in, be denied the benefits of, or be subjected to discrimination under any education program or activity receiving federal financial assistance. So this is a federal law intended to end sex discrimination in all areas of education. It applies to non-discrimination based on gender, to all recipients of federal funds in both public and private institutions. And it applies to issues of program equity, such as in athletics, gender equity, such as pregnancy accommodation, and sexual harassment and sexual assault. So some key areas in which recipients, meaning the colleges that receive the federal funding, have Title IX obligations are recruitment, admissions counseling, financial assistance, athletics, sex-based harassment, discipline, employment, treatment of pregnant and parenting students, and retaliation. And I will highlight retaliation is prohibited. A recipient of federal funds may not retaliate against any person for opposing an unlawful educational practice or policy, or bringing charges or testifying and participating in any action under Title IX. So this applies for students. If a student complains about a faculty member, that student still must be graded fairly. That student is still to be treated in the same manner as if they never had complained. And by the same token, this applies to employment. So as a faculty member, if you raise an issue with your chair or dean, or if there's any sort of issue that you raise, it should not impact your matriculation through the college to getting tenure. It should not impact your course load or your contract. Like, there should be no repercussion or retaliation if you raise an issue under Title IX. So there were new regulations finalized May 6th. They took effect August 14th. The full package of comments and discussion is 2,000 pages. I have not finished reading all 2,000 pages, but the changes themselves are about 30 pages, maybe, at the end of the document, 33 pages, I can't remember. And, but the changes were significant. We do have a new Title IX process that's available on the website. This color looks a little odd, but it's on pgcc.edu. And we're working to update the process to make it a procedure in the College Code. So there were a lot of changes, but the major changes, I'll start with what conduct is covered under Title IX. So the way that the regs are written now, everything is titled under the umbrella of sexual harassment. And I'm going to move to the next slide because that has a lot of the information for this point. Sexual harassment means conduct on the basis of sex that satisfies one or more of the following: an employee of the college conditioning the provision of an aid, benefit, or service on an individual's participation in unwelcome sexual conduct. So this can take many forms. It can be employee on employee. It can be employee on student. But the actor here is an employee in this context. Number two, unwelcome conduct determined by a reasonable person to be so severe, pervasive, and objectively offensive that it effectively denies a person equal access to the college's education programs or activities. Something I've seen recently, actually one was yesterday, one was last Friday in the press, a professor who for some reason decided to go shirtless and conduct his class without a shirt on. And it offended someone, one of the students, and she was very taken aback. And it was a male professor, female student. And so is this pervasive? Is it severe? Is it objectively offensive? So that, you know, she can no longer feel as though she has equal access to the education program, to that class. So that's going to probably go under this particular definition of sexual harassment. Something that happened early in the COVID timeframe. A professor was presenting and had in his URLs a pornography website. So the students did not see the website, but the students saw the URL up on the top of his screen that he had been in that site. So that was early on. Was it severe, pervasive, objectively offensive? Will be likely the rubric that it's handled under. But those are the sorts of things that are happening currently in this remote learning atmosphere that can actually come under Title IX as sexual harassment. The third definition, excuse me, is sexual assault, which is defined in a particular section of the US Code. A lot of this goes back to the Violence Against Women Act, sexual assault, dating violence, domestic violence, and stalking. Some people are more familiar with intimate partner violence rather than dating and domestic violence, but the administration took us back to these definitions, and sexual assault is defined as an offense classified as forcible or non-forcible sex under the Uniform Crime Reporting System of the FBI. So the forcible sex offenses include rape, sodomy, fondling, or sexual assault with an object. Non-forcible would be things such as non-forcible sexual intercourse, which includes incest and statutory rape. So those are all Title IX offenses. When we get to dating violence, it is violence committed by a person who is or has been in a social relationship of a romantic or intimate nature with the victim, and where the existence of such a relationship shall be determined based on considerations of the length of the relationship, the type of relationship, the frequency of interaction between the persons involved. And domestic violence includes felony or misdemeanor crimes of violence committed by a current or former spouse or intimate partner of the victim by a person with whom the victim shares a child in common, by a person who is cohabitating with or has cohabitated with the victim as a spouse or intimate partner, by a person similarly situated to a spouse of the victim under the domestic or family violence laws of the state of Maryland, or by any other person against an adult or youth victim who is protected from that person's acts under the domestic or family violence laws of the state of Maryland. And then we have stalking, which means engaging in a course of conduct directed at a specific person that would cause a reasonable person to fear for his or her safety or the safety of others, or to suffer substantial emotional distress. So those are the Title IX sexual harassment offenses. Another issue that's a major change is that Title IX is very specifically only for US-based persons, for conduct that happens in the US. So this would impact that Title IX does not technically reach overseas programs. If students are on an overseas trip, the conduct that happens there would be handled under the conduct code, the student code of conduct, not under Title IX. There is a requirement for Title IX cases to be handled under a formal complaint. And that is a very specific definition, which a formal complaint is a document filed by a complainant or signed by the Title IX coordinator alleging sexual harassment against a respondent and requesting that the college investigate the allegation of sexual harassment. So I, as Title IX coordinator, may sign a complaint in the absence of the complainant wanting to go forward if it would otherwise be considered that the college is not giving due weight to what has happened. But in general, third-party complaints will be taken seriously. Anonymous complaints will be taken seriously, but there must be a formal complaint in order for the college to go forward under Title IX. There are no longer informal complaints. And if something rises to that level of actually being sexual harassment, if that is deemed to have happened, if one of these things is deemed to have happened, including stalking, then it will go to a formal hearing. And that is also a requirement, that anything that is a formal complaint go to a formal hearing. And this was a huge shift. It is what caused the biggest uproar around the nation in changing this, because it is felt that complainants will be less likely to file and to go through with a Title IX complaint because of the requirement of a hearing. And we'll get a little bit more into the hearings a little bit later. The other requirement is supportive measures being non-punitive. These used to be called interim measures, as kind of temporary things that would happen. We can still do emergency removals, but it is not as simple as it may have used to be. So if someone has done something that someone's complaining of, it does not mean that that person will be removed from the college, removed from the classroom, removed from being able to participate in the college's education program. If someone is deemed needed to undergo emergency removal, that person has a right to an immediate hearing. And that is another shift, because the person has the ability to say, look, some of these facts are just so far out from being the truth, it's not fair to me that I have to now stop attending school. And again, Title IX is about equity. It is about preserving everyone's right to the education program, and removing someone from the college, disallowing that person to attend classes online, or the few that we have on campus, will significantly impact that person's right to matriculate through the program. It will impact financial aid. It will impact grades. It will impact that person's ability to complete. And the goal of this administration has been to equalize the rights of the person making the complaint and the rights of the person accused to be considered not responsible until it is proven. All of the complainants and respondents are required to have advisors. They can opt not to have an advisor, but the challenge with that is that if we get to hearing and they all of a sudden want an advisor, the college has to provide that. Some students may not have an advisor. They may not have a family member or a friend that they choose to have be an advisor. Therefore, the college is required to supply advisors. In Maryland, it is a Maryland requirement that complainants and respondents are given an attorney, not paid for by the college, paid for by MHEC, or the state of Maryland has the budget. And my belief is that this is in sexual assault cases only. We have been told that it is for all sexual assault cases in several trainings that I've gone to. I do not believe that's accurate from reading the law. I am seeking a ruling on that from MHEC, because MHEC is the keeper of the list of attorneys that will be providing this service. And I went to one of the trainings. I am an attorney. I'm not acting as an attorney, but I was curious what the attorneys were going to be trained to say. So I was able to go to that training. And I believe that this is a requirement only for sexual assault cases. It will make the mandatory hearings a lot more formal and complicated. The mandatory hearings have a requirement of cross-examination of all parties, complainant, respondent, witnesses. The parties are not allowed to cross-examine one another. That's where the advisors come in. The advisors are required to do the cross-examination. There will be evidentiary rulings. Whatever's presented as evidence will be discussed, and a ruling will be made on whether it is allowed or not allowed. And there's increased scrutiny on conflicts of interest. So I, as Title IX coordinator, am allowed to manage the hearing in terms of witnesses and who's where and what's next. I am permitted to investigate. The investigator, in this case me, will not render opinions and recommendations, but will summarize the evidence, moving it toward the hearing. So the idea being that Title IX coordinator should be impartial, should be a resource for everyone, and there will be others who will have to do decision making, and that process looks a little different. I see we have a lot of questions, and I'm going to see whether I can address any of them because my time is running short. A couple of these go back to ADA, and so I'll see if I can answer those at the end. Does student-on-student sexual harassment fall under Title IX? Yes. Yes. Title IX covers conduct prohibited regardless of whether it involves employees or students of the same or different genders. So that's where the answer lies. Yes, student-on-student, student toward employee, or employee toward student, or employee toward employee. So any combination of employees and students of the same or different genders can be a Title IX sexual harassment. And so sexual harassment, as I said, it's all conduct that would be considered sexual harassment is prohibited, and it's in either category: employees, students, same or different genders. Online sexual harassment and misconduct, our policies are written and interpreted so that online and cyber manifestations of any of the prohibited behaviors can have an effect on education program and its activities, on the ability to matriculate through. And so that would fall under Title IX. So if there's cyber stalking, if there's any sort of harassment during class, that is something that could be brought under Title IX. And now we're at pregnant and parenting students. So the issue with pregnant and parenting students, and in general, pregnancy, at least as of today, is limited to women as a physical manifestation. And so the issue with it being under Title IX is that it is sex-based, it is gender-based, and it can keep a woman from equal opportunity to be in an academic program or in the college's program. So that would include athletics. And so the goal is that the school treats the pregnant student in the same way as similarly situated students, that special services that would be provided to students with any temporary medical condition also applies to pregnant students, that the students really are being able to return to the same academic and extracurricular status as before the pregnancy, the medical leave. So the issue here, I know, is the challenge between what's pregnancy and when does it become disability. And I have, frankly, with the new regulations, not been able to finalize the pregnant and parenting procedure that I wanted to present to the president to see whether this is something that we can adopt as a college. In some of our meetings with pregnant and parenting, about pregnant and parenting students, with several of the deans across the campus and chairs, people have given their time and their feedback to me, and I am nearly closing in on finishing what I consider to be a fair procedure for the college. In general, the student does not If the student gets into the realm of disability, if it goes into a length of time beyond the pregnancy, especially extending beyond the pregnancy, that is when it becomes something that is considered more of a disability and would go through disability support services for the written and full accommodation. In general, when students are pregnant, they usually are able to handle this one-on-one with their instructors in terms of making up work, getting slight extensions, missing a class because of doctor's appointments. Usually this works out pretty well. There are a few times when it's a sticky situation, often includes labs or clinics or things of that nature. And I've seen more of it with culinary arts. It's, I think, consistently happened within some of the allied health and nursing programs, but it is something that we have to enable that student to make choices about her pregnancy, about whether she feels comfortable being around certain chemicals, doing certain procedures, being involved in certain processes. That is not something we can exclude the student from in a way that does not comport with law. So I think there's certain things that may be true in the allied health and nursing segments that's not a written rule or nothing, that it's not regulated in, for example, chemistry, for a chemistry lab, or for culinary arts. So there may be laws that govern how students interact with certain things, but in general, it is not something that we get involved in telling a student that she cannot participate in athletics or in classroom activities because she is pregnant. And the question, what about men? There's no support for their situations. Not entirely true. That's why we're looking to create the process is that men, in terms of attending the birth, certainly there would be some accommodation there. The challenge is that men can have more than one birth happening in a particular semester in a way that women typically don't. I have personally known women who've had twins and they were not born the same day. One twin was born and the other was still gestating for 2 months. So I've seen women have more than one birth in a particular semester of time, but men, certainly that's possible in a more practical, regular way. But yes, I think as an institution, we would not discriminate against the man by saying you could not attend the birth of a child. I don't know about every doctor's appointment. That's something that I think we'd have to talk through, and that's one of the questions that I want to ask of the president and of the institution is, what does that look like? Is it that we are giving the ability for him to attend doctor's appointments, and what documentation are we requiring from him in the same sense that we would require from someone who has a broken arm and says, I have a doctor's appointment with my orthopedist and therefore I have to miss class. Like we cannot treat pregnancy differently from other medical scenarios. So that's where this becomes challenging. We cannot have faculty members treating, someone who comes in with a sling much differently than he will treat someone who comes in and says, my spouse or my girlfriend is pregnant and I have to go to her appointment. Cannot require a note from one and not from the other. So that's where it gets sticky. That's where other colleges just don't have policies and procedures and specifics on it. Everyone wants to say it's case by case, but these cases are very similar. These are not things that are unusual. So I think that we can do the hard work of coming to decision on it and seeing how we want to play it out here. What to do if a student approaches you with a pregnancy or parenting issue. Tell the student that the student has rights under Title IX. As I wrote here at PGCC, men are also given limited parenting rights. Inform the student that I, as the Title IX coordinator, and the Deputy Title IX coordinator, Kathy Camp, are available to discuss these rights and coordinate to ensure that all protections are given. What not to do: do not ignore the disclosure. Do not send the student to the wellness center. Do not tell or suggest to the student that the student should, must or should consider withdrawing from your class. Transgender and non-binary. So this is the list of terms: lesbian, gay, bisexual, transgender, queer or questioning, intersex, asexual, or ally. These are the terms that I showed last year that describe the different categories of individuals that fall under LGBTQIA. And here we have transgender, or trans being an umbrella term that describes people whose gender identity and or expression differs from the sex they were assigned at birth. It's a term used to describe people who identify as a different gender from the sex they were assigned at birth. Being transgender does not imply any specific sexual orientation. So transgender people may identify still as straight, gay, lesbian, bisexual, etc. And so this is, these are terms that I think folks may be less familiar with, less comfortable with. And as I said before, it is important for us as an institution to respect all individuals, and whatever our personal beliefs or views are, that does not trump the ability and the need to treat everyone with respect and dignity under the law, and to do our jobs in a way that is fair and is just and equitable, and so that people are treated equitably and get to matriculate through the college's education program. And that is what's important here. Intersex, as folks may know, the term is used for about 2% of babies who are born with naturally occurring variations in chromosomes, hormones, genitalia, or other sex characteristics. Asexual and ally. So within the LGBTQIA, there are people who speak out or take actions on behalf of others in the group, and allies may be straight. They may identify with the gender assigned at birth. This community for LGBTQIA is a robust community full of everyone. Anyone can be a member of this community. Then there are additional terms that I'm still getting familiar with, and cisgender is a term that describes a person whose gender identity aligns with the sex assigned to them at birth. So for instance, I would be considered cisgender. I was assigned the gender of female as an infant, as a newborn, and I identify as a female, I identify as a woman. So I think that these terms are also important. Binary being kind of like the computer code idea of binary 0 and 1. Gender binary is the idea that there are two distinct and opposite genders, male and female. And you may hear people saying that they are non-binary, meaning they do not consider themselves either male or female. There's the gender spectrum, the broad range along which people identify and express themselves as gendered beings or not, and gender identity, an internal, deeply felt sense of being male, female, a blend of both or neither. So this is, again, going to gender and to terminology, there are different orientations that people take when we're talking about relationship between individuals, and not just how I see myself, but how I see myself sexually in relation to others. And these are some terms here that I'm welcome to share with anyone who wants these, because we don't have time to go through specifically. The actual or perceived sexual orientation or gender identity of the parties does not change a school's obligation. So this is something that is really critical that we understand. If a student identifies to you through email before classes start that there's a preferred name that they would like to be called, I need to work with now the new registrar who was just identified to see how we can deal with preferred names on the roster. But understand that if a student was identified as male, the gender identity was assigned as male, and let's say his name is Robert, his given name is Robert, he has to apply for financial aid using that name. But if Robert has now identified as being female, then she may take a name of Barbara, and that may be her preferred name. So a professor who calls for Robert on the roster in the first day of classes has now outed Barbara, who may be appearing as a woman, as being transgender. And that is a huge challenge then for Barbara to matriculate through that class with that set of students, already knowing something that maybe Barbara was not going to share and was not obvious. So that this is really critical for us as an institution to get right, because it is a huge violation of Barbara's rights, and it puts the school in peril, and it puts that student in a very, very uncomfortable and difficult position. So we're really hopeful that we can move this piece along and have preferred names absolutely done well here as an institution. And then we've got the pronoun slide. I am doing much better at being gender neutral and saying they, their, them. I was not good at that when I first started here at the institution. And this is something that is also available to you if you'd like to have this slide. I'm going to glance real quickly at the chat. I think we can capture these, and I will respond to people individually on this. I will say, student reveals pregnancy after class is over. No, we have to limit it some way. I think the goal I have is to get the word out to students that they can get accommodations and that they should seek accommodations, whether it's through me and the Title IX office or not. But we absolutely cannot just retroactively at the end of everything do that, absent an extenuating circumstance. You know, at times women may not know they're pregnant and they miscarry. And then there's an impact. Certainly that is something to be considered. If a woman is having a perfectly fine pregnancy and has no complications and has asked for no accommodation and all of a sudden has a stillbirth, absolutely the pregnancy itself is over, but the impact from the pregnancy remains. So I'm not going to say there's a hard and fast in that way, but there are, because there are extenuating circumstances and we need to be human about that. But this is something that that we will work hard to get right and to try to get consistency for everyone, so that everyone can just do their job, and whether that's as faculty, as a student matriculating, just to make it easier for everyone. And again, we now have a Title IX at pgcc.edu. I will be monitoring that closely. I'm going to see whether I can have that pushed to my phone. I don't know that I can, but I am going to monitor this very closely. But I also have my email address. There's Kathy's, and then Lynn Adams is a deputy Title IX coordinator who deals with employee-related incidents. Most of what happens is assigned to Kathy and me as overseeing, but where there's an employee involved, Lynn does get notified. So this is where we are in terms of the official team. And I will make it a point to get the rest of the chats and make sure I respond to you individually about whatever questions. I've seen hands being raised. That is not showing up on my screen. I see it when it flashes, but I'm not sure of all the hands that were raised, and I'm hoping that I can capture that and maybe give a call and answer your questions. There's also externally ways to report Title IX violations. We certainly hope that you report internally first and try to get it handled, but there are external ways to report as well. And now we're on to student conduct with Kathy Camp, Interim Vice President for Student Affairs and Deputy Title IX Coordinator.
Good morning, everyone. It's so nice to have all of you attending this morning for this important information. I will try to be as brief as possible. For many of you, this is probably your second, third, or fourth time hearing about student conduct, but it is important that we all know. Next slide, please, Susan. As you know, the Student Code of Conduct is approved by the Board of Trustees. And in recent times, you may know of the changes maybe with my policies, and now some of the procedural things have been separated from the policy, but the current Code of Conduct was approved in its entirety by the Board of Trustees. The purpose of it is to guarantee that students have certain rights and that they understand there are certain responsibilities that they also have to put forward those college policies and procedures. It provides the students the policies and the expectations of their behavior when they're on college property. And as Susan has indicated, within the Code of Conduct, this also includes behaviors in a virtual or online environment. We're attempting through our conduct process to provide an educational and a developmental process so that we balance the interests of the student and the interests of the college community. So we're hoping that we teach them something through their interaction with the conduct office. The Student Code of Conduct is put forward to students in a variety of ways. It's part of the student handbook and daily planner, and I'd like to make sure you all are all aware that for 2021, this coming year, the handbook has not been printed. It was a cost-saving measure, and so it is only online. It is also on the college website. The academic integrity portion is discussed in the past curriculum, and it is provided, although for fall 2020, all of these orientations are virtual, but it is provided to all of the different orientations that we interact with students. What should be reported? Well, the reporting goes into a system called Maxient. It's our conduct management system. But these are the things that you should submit an incident report, and I'll go into how you do that in just a moment. Student conduct violations, the graphic on the left part of the slide is the categories, if you will, of the different violations, the broad categories, and anything that you believe is behavior that violates those tenets should be reported. Grievances, which are, considered wrong or unfair treatment that are not Title IX, have a different category. So it's Title IX as she's just described, if it deals with certain categories. But all of those things should be reported. And if you just have concerns about a student, or there's been some interesting behaviors that you've witnessed, it is very important that you report that. So just so you know, just because you report it doesn't mean there's some sort of judicial action that happens. but we have a way of responding with a multidisciplinary team of people to look at the issue and figure out what is the best way to maybe intervene so that it doesn't become something that is a behavioral violation, or perhaps the student is in need of assistance that we can directly provide. These are the ways that you can submit the report. In my PGCC, as the graphic shows, there's a incident report form on the banner. It's also on any of your devices or the teaching terminals if you were in the classroom. And it's also available on the website when you get to the Student Conduct and Community Standards page. You can submit, the incidents are submitted, and it asks you certain kinds of questions to provide us with basic information, and all of those things are routed specifically to my office, and then, or we have routing rules depending on what the category of the violation is that you choose, but it is very limited, the people who see this information, and we get it to the appropriate party. So for example, if you submit a Title IX report, or a student does, because anybody can report, you don't have to be affiliated with the college. It's a web-based incident reporting system. This is also how students can submit complaints. It's all in the same system. And we just categorize and handle those through the group of people who have access. It's very limited access depending on the category and type of incident that is reported. A basic conduct process is that the incident report is submitted in the Maxine system. A case is created, and then there's an email and mailed letter to the respondent, which is what they become in a conduct situation. And if it's reported by the faculty member is copied on that letter. We begin an investigation. Those are the items that may be considered. And students are given initially the opportunity for an informal hearing, which we call a student rights information session. And at that session, there's a form and a set of rights that we go through with each statement and ask the student to sign so that they have been given knowledge of their rights. We present all the evidence that we have to the student, and then the student has the opportunity to accept the evidence and whatever decision may come, or they may request a formal hearing, which would be recorded, which would have people in the room. Of course, they can't, as Susan explained, they don't ask questions of each other, but the conduct officer would be kind of the mediary between those discussions. And then a formal hearing, a decision is rendered, and the potential disciplinary action or sanction, such as it could be an educational assignment, it could be probation, it could be suspension, and so on. And the student has 10 days to appeal the decision. And when an appeal is received by my office, then a student conduct board, so there's a group of people who we pull, one from each constituency, to have three people and a chair sit through the board process with students for this appeal. The appeal is not about rehearing the case. Appeal is more about how process was not handled correctly, or they're appealing the severity of the decision or the sanction. Academic integrity is a concern to all of us. It is a shared responsibility. It is helpful that students have to be responsible to know and understand it. It is also important that you, in partnership with us as faculty, make sure that they're aware of the importance of the integrity of their academic work. If you suspect, now I don't want to confuse the situation, but what you will see posted is the former academic integrity policy. And there have been people who have, from the faculty and from student affairs, who have worked very hard on a revised academic integrity process. And so that will be going into effect this year. The issue was it was all getting approved and everything was kind of happening when we went to remote work in COVID and had to get the My Policies in. So as you see it now, we will be able to change the nuances of how we will be handling academic integrity. But by and large, these statements are still accurate. If you suspect plagiarism or cheating, we need for you to gather and present the evidence to the student, obviously, which you would do. And the student has the opportunity to admit or deny the allegation you've brought forward. You should submit an incident report form, like the ones we've just mentioned. You would submit that through Maxient, the incident report form. It allows you to select that it's academic integrity, so then it asks different questions. And then that would be received by my office. We appreciate any evidence that you have and that you update. You would upload that incident if it's a paper and you have the source, and anything you could present in that evidence is appreciated for the documentation. You are to assign a grade of 0 for that assignment. The students are given a warning for the first academic integrity violation. They're found responsible. Now, the changes that are happening in our process is that instead of it just going to my office, the provost's office will be walking in tandem with academic integrity matters. So the student receives a warning. The second academic integrity violation would be a failing grade for the course wherever the second violation occurs. So what we have done away with is what previously existed as the F asterisk that went on the student's transcript. Now, when a student has committed 3 or more, then this results in a judicial record. And by that, I mean they've crossed into a student conduct process that I just mentioned. And likely a suspension will be the result of that. But we'll have to follow the conduct process as previously stated. In all of this as well, students have a right to appeal. And in the new policy or procedure or process, there were some time frames submitted, because sometimes we'll have academic integrity violations, and because everyone's very busy and grading and whatnot, it can take some time for those things to be submitted. And so it's asking that from the discovery of it, that there be 15 days is the maximum to me submitting those, so that we can handle these things a little more timely. And the other issue is that sometimes students are determined to have done an academic integrity violation, let's say a discussion board post and then a paper, and it's all in a short period of time. Those things are submitted to my office all at the same time, and unfortunately that is considered one if they come in on the same day, even though there's multiple different reports. So we're trying to help streamline those sorts of things so that we can be in front of that, educating the student before they are violating it a second time when possible. This is just kind of a reminder of things that we've seen happen, so that notes are not put in the STRK place in Colleague or in the Navigate system. If you have access to put in notes there, and for example, things that you may put there would indicate something that's private. So if you say you refer a student to Disability Support Services, you've just shared that the student has some sort of potential ADA accommodation, and that was not something that should be shared. Or people will say, referred to Thomas Meigs. Well, most of the people at the college know what that means. So be mindful of the comments that you put in the system. We typically, in student affairs, we will just say for multiple things that we refer the student to Lanham Hall, because that's a wide variety of things that our student supports in Lanham Hall. And we've had some issues where I don't know how that would be happening in the virtual world, but it still could be. In a get to know each other kind of way, The faculty have asked students to exchange phone numbers, and that has ended up in some really interesting Title IX situations. So you should not require the students to exchange phone numbers, because even though it's well-intentioned, it can go awry very quickly. I appreciate Dr. Raley sharing that that's been the holdup. We had to get everything done, and that it will go back to college-wide forum, the academic integrity policy. We needed to bring it back in September, and then those changes can be made. And because it's not printed, it will be made live on the online version of the handbook.
Kathy, you see this no more F with an asterisk? That's a question.
That will be the case once the college-wide forum moves that forward and Dr. Williams signs that. The intention in the discussion was that it was really kind of long-term punitive for a student, and they thought it was more important, I'm trying to speak for a group of people, that we move more quickly through the different violations to get to something that, so we don't just have a student with F asterisks, but they can continue being a student here. So there was a different approach and a thought that we wouldn't want to be an F asterisk permanently on a transcript. But we also didn't want to have a student who continued to violate our academic integrity policy as a student at the institution.
Did you see this last question for the first offense? For the first offense, academic integrity, an assignment grade of 0 could result in the student failing the course. Will the college interfere with that result? Is faculty obligated to ensure that the student doesn't fail the course because of the assignment grade of 0?
No. The reason it is very specific about assignment is, let's say I plagiarize my discussion board post. That punitive grade for me is weighed differently than if I cheat on the final exam, which in theory would have a higher percentage rate of the grade. So the assignment in which the violation occurred, that assignment and its associated weight and point value would be given a 0. It could end up that they failed the course because perhaps they've done poorly on many other assignments. So you don't have to prevent them from failing the course, but as a result of a violation, they don't automatically fail the course on the first violation.
And then there was a question, are faculty involved in the formal hearing? I think that's for you. For me, faculty are involved if they are witnesses or parties. So for Title IX, that's when faculty would be involved in a Title IX hearing. But for your hearings, Kathy, are faculty involved in the formal hearing?
If they're involved in the incident report, they are certainly invited and asked. There are times when they will submit their statement in writing and not be able to attend, and typically they are invited to the formal hearing if they're the ones that certainly reported the incident or were a witness in some way for either the respondent or the complainant.
And I think we're at time, but there was one more. What about cheating that occurs with specific patterns? Is that a violation?
What about cheating that occurs with specific patterns? I don't see the question. What do you mean, specific patterns? So that in the same course, they are doing the same, they're on discussion board posts, let's say they're plagiarizing each one. I would hope that those would be separated out, not reported together, so that could be an education as to what the violation is to prevent the next one. That's the hope. I also want to say before I'm out of time, you're always welcome to contact myself or the Office of the Vice President for Student Affairs. We are currently, and have been for 9 months or so, without our program coordinator of student conduct and community standards. And Mr. Johnny Owens in my office has been handling the cases and the work of that position. We are at the final stages doing a background check on the person selected for that position and are hopeful we will have that person in place soon after the beginning of the fall semester. So we will announce and introduce that person to the college community. But if you have any other questions or concerns related to the conduct process, or if I can assist with it in any way with any student issues that you have, please feel free to reach out to me, and my contact information was provided on Ms. Watson's slide related to Title IX.
And we will get back to folks that have asked about this, asked questions that we have not been able to get to here.
The email address question, the email address is a much better way to have students share information. It's not foolproof, but it is certainly better than their personal cell phone, especially if it's their student email.
Right. Well, thank you, everyone. I think we're beyond time. So again, you know how to contact Kathy and me, and I will get back to you. We'll look at these questions and get back to you on it. And have a great day. Enjoy the rest of opening week.